On this vote, the yeas are 224 and the nays are 201. The motion is adopted. Without objection, the motion to reconsider is laid upon the table. The unfinished business is on the vote on the motion from the gentleman from Florida, Mr. Dunn, to suspend the rules and pass H.R. 1159 as amended, on which the yeas and nays are ordered. The clerk will report the title of the bill.
H.R. 1159, a bill to provide for continuing cooperation between the National Aeronautics and Space Administration and the Israel Space Agency and for other purposes.
The question is, will the House suspend the rules and pass the bill as amended? Members will record their votes by electronic device. This is a 5-minute vote.
The yeas are 411, the nays are 0. 2/3 being in the affirmative, the rules are suspended, the bill is passed, and without objection, the motion to reconsider is laid on the table.
House will come to order. House will come to order. Members, if they could take their conversations to the back of the chamber or out of the chamber. For what purpose does the gentleman from Texas, Mr. Henserling, seek recognition?
Mr. Speaker, pursuant to House Resolution 657, I call up H.R. 4015 and ask for its immediate consideration in the House.
The clerk will report the title of the bill.
Union Calendar number 333, H.R. 4015, a bill to improve the quality of proxy advisory firms for the protection of investors and the U.S. economy and in the public interest by fostering accountability, transparency, responsiveness, and competition in the proxy advisory firm industry.
Pursuant to the House Resolution 657, an amendment in the nature of a substitute consisting of the text of Rules of Committee, print 115-46, is adopted and the bill, as amended, is considered read. The bill, as amended, shall be debated for 1 hour, equally divided and controlled by the chair, ranking minority member of the Committee on Financial Services. The gentleman from Texas, Mr. Henserling, and the gentlewoman from California, Ms. Waters, will each control 30 minutes. The chair recognizes the gentleman from Texas, Mr. Henserling.
Mr. Speaker, I ask unanimous consent that all members may have 5 legislative days in which to revise and extend their remarks and submit extraneous materials on the bill under consideration.
Without objection.
Mr. Speaker, the House is not in order.
The gentleman is correct. The House is not in order. The House will be in order. Take your conversations off the floor. The gentleman is recognized.
Mr. Speaker, I yield myself as much time as I may consume.
The gentleman is recognized.
Mr. Speaker, I rise in strong support of H.R. 4015, the Corporate Governance Reform and Transparency Act of 2017. And I thank the sponsor of this legislation, my good friend Mr. Duffy of Wisconsin, the chairman of the Housing and Insurance Subcommittee of our committee, for offering this bill. Each year, Mr. Speaker, public companies hold shareholder meetings where shareholders vote for the company's directors and on other significant corporate actions that require shareholder approval. Mr. Speaker, the House is not in order.
The gentleman is correct. Ladies and gentlemen, the House is to be in order. Take your conversations off the floor. The gentleman is recognized.
Mr. Speaker, the Securities and Exchange Commission requires that before these annual shareholder meetings take place, public companies must provide shareholders with proxy statements that include all important facts about matters to be voted on at a shareholder meeting. Many shareholders and investment advisors rely on information provided by proxy advisory firms to guide their votes on these matters. H.R. 4015 would enhance transparency in the shareholder proxy system by requiring proxy advisory firms to register with the SEC, disclose potential conflicts of interest and codes of ethics, and make their methodologies public. Mr. Speaker, this is a pure disclosure bill. Nothing more, nothing less. Proxy firms play an outsized role in the U.S. economy in shaping corporate governance. They counsel pension plans, mutual funds, and other institutional investors about how to vote the shares of corporations that they own. With respect to institutional investors, Mr. Speaker, the share of institutional investor ownership was roughly 46% as recently as 1987, but today that figure is more than 75%. In other words, the volume of proxy votes for which investors are responsible has grown into the billions. In 2003, the SEC adopted a rule under the Investment Advisors Act that requires an investment advisor to vote in the best interest of their clients on proxies. A series of SEC no-action letters give the investment advisor a fundamental safe harbor from liability if they use a proxy advisor. As a result, institutional investors have increasingly relied on proxy advisory firms to help them decide how to vote their shares. However, regulators, market participants, and academic observers have highlighted potential conflicts of interest that are inherent in the business models and activities of proxy advisory firms. The committee, for example, is aware of numerous instances whereby the two largest proxy advisory firms have issued vote recommendations to shareholders that include errors, misstatements of facts, and incomplete analysis. For example, in one instance, a company reported that even though the total shareholder return the company actually had generated for its shareholders was 64%, the proxy advisory firm Glass Lewis erroneously reported this calculation to be 26%. Another company reported that ISS erroneously reported that the company's long-term cash awards will vest and pay out their maximum opportunity in the event of a change of control. Well, this was reported even though the company's plan had been amended and approved by the shareholders years earlier in a manner that would pay out at target upon change in control, and there are many other examples. Some proxy advisory firms' recommendations have been made without any contact to the public company at all, and then these same proxy advisory firms encourage companies to join their service in order to have the privilege to, quote, influence an advisory firm's recommendations. I suspect for many people this simply does not pass the smell test. An industrial company told its shareholders, Mr. Speaker, quote, ISS's negative recommendation was based on flawed analysis of our compensation programs that did not appropriately take into account the significant declines in our CEO's pay in 2015 or the performance-based nature of our annual and long-term incentive compensation programs. A pharmaceutical company responded to a proxy advisory firm's recommendations with this statement, quote, for the second year in a row, Glass Lewis did not include its full pay for performance analysis in this report. For shareholders who rely only on Glass Lewis materials to make voting decisions,